Welcome back to Winning Isn't Easy, how First Reliance successfully terminated a lawyer's benefits for chronic fatigue syndrome. Now, in this podcast episode, we've been talking about various occupations, the proof that is required to prove that you can't do your own occupation, the importance of objective medical findings on exam and by diagnostic studies, not doing things that are inconsistent with the nature of your occupation or your complaints about your symptoms. And that's going to hold true in our discussion here about how First Reliance successfully terminated a lawyer's benefits for chronic fatigue syndrome. I will tell you that disability insurance policies or plans place the burden of disability, of proving your disability, on you. They'll often require proof of total disability, regular care from a physician, completion of the elimination period, submission of satisfactory proof, and the failure to do any or all of that can result in a claims denial or termination. Chronic fatigue claims, fibromyalgia claims, those are the kinds of claims that present unique challenges because generally there is no definite test for the diagnosis. Think about migraines too. There's no gold standard test for migraines. Chronic fatigue syndrome, maybe there's some objective findings, laboratory findings, same way with fibromyalgia, but more often than not, based on a physical examination that in part is based on subjective complaints. And insurers will exploit this by demanding objective evidence when in fact it doesn't exist based on the nature of the disease, but nonetheless insist by the terms of the policy or plan that is required, and sometimes it is, and sometimes saying, well, there may not be an objective basis of the diagnosis, but there sure as heck is no objective basis for the restrictions limitations. So let's talk about how this plays out, particularly in the case of a lawyer. In the case of Burris versus First Reliance, an attorney claimed disability due to chronic fatigue syndrome, and he provided support letters from his wife, his mother, and his self-assessment. What happened was that First Reliance raised the common defense that, look, this diagnosis is based on self-reported symptoms. And the court upheld the denial, saying, look, you've got to provide objective evidence of functional impairment. Now, you may not have to provide functional evidence of the diagnosis, but you sure as heck have to provide evidence of the restrictions and limitations. So how do we go about doing that? Well, in the case of chronic fatigue syndrome or MECFS or fibromyalgia, there are certain tests that you can undergo. There's a CPET test that will, for example, document the fatigue associated with MECFS. There are physical exam findings testing called functional capacity evaluations that will measure a person's ability to engage in sitting, standing, stooping, walking, bending. In the context of a migraine case, we also do, by the way, functional capacity evaluation tests. And I want to do them when my person is having a blinding migraine because I want a third party to potentially videotape or observe what's going on with the migraine and how the person may be vomiting, how the person may have postural issues, bending over, trying to pick something up, and they have the migraine syndrome symptoms, maybe even some dizziness or syncope. We want to have, in those instances, an objective third party presenting evidence of the functional reasons why the person has restrictions and limitations. Then, of course, we've got to tie it all together. In the case of a lawyer, we sit, we stand, we walk, we bend, we pick up briefcases, we argue cases, we analyze things. And so we want to be able to document not only physically why we would be unable to do those things, work 12, 14, 16, 18 hours, be in a courtroom, think, write briefs, but we want to also supplement that with, as appropriate, the testing, the MECFS testing that shows the fatigue, the need to take naps, the functional capacity evaluation that documents the inability to sit, stand, walk, stoop, bend, to have the endurance to maintain the physical requirements of a person's occupation. I am leery about psychological testing, particularly if the policy has a mental nervous policy limitation. But in the right cases, we'll even do neurocognitive testing to document the impact of the fatigue, and other symptoms on a person's cognition. So, what happens, of course, in these cases is we want to look at the definition of disability, occupation, and proof requirements in the policy of the plan. Secondly, we want to understand policy limitations. Is there a mental nervous policy limitation, a subjective limitation? Because many times carriers will argue that these types of claims are limited to just 2 years if there's a subjective medical condition limitation provision. Next, we want to understand what's in those medical records. Is there a great medical history of symptoms and functionality? Is there objective proof of the diagnosis, be it based on physical exam or diagnostic studies? Is there an objective basis for the restrictions and limitations that have been assigned? Is it consistent with the nature of the treatment that's being provided, with the level of complaints? Is it consistent with the lack of social media postings? Is it consistent with what family and friends are observing and saying? Is it consistent with any logs that a person might be keeping? For example, a migraine log. Is it consistent with a physician's observations when the patient presents at the doctor's office? Is it consistent with what the doctor has to say about a person's restrictions and limitations and functionality? All of this will play together in proof. So again, you've got to figure out what's the occupation as defined, what are the material and substantial duties, what's the objective basis of the diagnosis, what's the objective basis for those restrictions and limitations, how can we tie it together with proof of a lay nature, and how do we prove it objectively based on objective testing, and how do we tie it all together with vocational opinions. You can see that this is a comprehensive strategic approach to your particular occupation, your particular disease, the particular policy requirements, and of course, whatever is going on in your particular federal circuit in terms of proof requirements. Got it? Now, I thank you for tuning in to this week's episode of Winning Isn't Easy. If you found this episode to be helpful, take a moment and like our page, leave a review, share it with your family or friends, and subscribe to this podcast, please. By the way, you may note that in our show notes, we have a place where you can send us questions or comments. We might even feature your questions in a future episode. And I'm actually looking forward to doing an episode just full of people's questions. So I want to make sure that you're not walking away from these podcasts with some question that's burning in your mind that you just want to know the answer to. Got it? Thanks. And we look forward to hearing from you.